I would like to start with a few words to thank the organizer. First, for the interest of the topic. As a General Court of the European Union, we mostly control the legality of what the Commission is doing, so we tend to hear a lot about fines. But it is quite a unique opportunity to give an opinion on a draft proposal. There's a reason why I would like to thank the organizer. They're giving me the possibility to deliver a speech in English, which for a Frenchman is always somehow challenging. I'll divide my speech in two parts. The first one will concern the legal status of guidelines on fines in EU law, as well as the advantage they represent for both parties, the undertakings, but as well as the Commission. And in the second part, I will concentrate on my own and personal, and I emphasize on that personal, opinions on the draft proposals. So, what are guidelines on fines in European Union law? Well, they are self-imposed rules by the Commission in an area in which it enjoys wide discretionary powers. Wide discretionary powers because if one looks at the relevant legislation, first Regulation 17, now Regulation 1/2003, there's absolutely nearly nothing about fines. There's only three elements. The Commission must take into account gravity, duration, and cannot go beyond 10% of annual turnover. That's it. And the Commission came under quite a lot of pressure from the business world, but also from the Court of Justice and the General Court, which led to the adoption of guidelines on the setting of fines in 1998, which were repealed and changed in 2006 in a way which might not be entirely favorable to the undertakings. Now, those guidelines cannot be analyzed in an isolated ways. They are part of a wider picture in which you have other notices and guidelines, and one is very important, is a leniency notice. The application of the 2006 guidelines can lead to very important amount of fines, but they can be substantially reduced if the undertaking is willing to cooperate. Now, I am saying that guidelines are ensuring legal certainty for the undertaking concerns, first. They ease the work of the Commission, second. But third, it must be kept in mind that there are no regulation and their legal status is somehow limited. Why do they ensure legal certainty? Not because they are explaining what the Commission is willing to do, that is part of the answer, but also, and I'd like to put the emphasis on that, is because they are enforceable before the General Court. If the Commission departs without due justification from the methodology it's set up, then it can lead to an annulment of the decision. So there can be certainty for the undertakings that the methodology as a principle will be respected. For there to be proper enforceability, I would suggest that you need to have two elements in guidelines. The first one is a clear expression of the intention of the author of the document, the Commission, to bind itself. The second one is that you need to have a wording of the provision which is sufficiently clear and precise. And here I can draw quite a distinction because, Mr. Chairman, you mentioned the difficulty of defining the relevant market. Well, we have a notice on the definition of the relevant market in EU law from 1997. This document is also adopted in an area of discretionary powers, and it gives a certain number of ideas. It's a useful document, but it's nearly impossible to rely on it in front of the EU court, because the Commission offers alternative ways of defining the market without prioritizing them. So when you have this kind of vague wording, then there's no real legal certainty. There's flexibility, of course, for the administration, but there is no legal certainty. The fine guidelines, the 1998 one, maybe a bit less, the 2006 one, the leniency notice are drafted in a way which is sufficiently clear to be enforced in front of the General Court. So they do provide legal certainty. That's for the undertaking concerns. But they also represent benefits for the Commission. What is a benefit for the Commission? Well, it facilitates the work of the Commission. Under EU law, there's a very strict duty to state reason. The Commission must explain in the greater details why it reaches a decision, especially in the field of competition law, where now we are finding abuse of dominance above 1 billion euros. Yet, if you look at a decision like Intel, which is a very lengthy one, the vast majority of the recitals were not on the amount of the fines. They were on the definition of the market, they were on fidelity rebates, they were on all issues pertinent to the issue of whether there is an infringement. But when it comes to the actual recitals on fines, which led to 1 billion, there are not that many. Why? Because the Commission was in a position to say, well, I am making use of my fining policy. So the reasoning is somewhere else, you can make reference to it. So it is the work of the Commission, it provides legal certainty for the undertaking concern. It's a perfect world. Well, not really, because, that would be my third point, guidelines are no regulations. There are no regulation because there's a principle which I think we can find in the administrative law of many member states, is that when the administration fetters or limits its discretion, it must be ready not to apply its guidelines in exceptional circumstances. Otherwise, it is adopting a regulation and it has no power to do so. So very early on, the Court of Justice and the General Court made clear that the Commission must be ready not to apply its guidelines in situation exceptional. And that's something that wasn't considered in the 1998 guidelines. Now it is clearly stated in Recital 37 of the 2006 guidelines, which states, although these guidelines present a general methodology for the setting of fines, the particularities of a given case or the need to achieve deterrence in a particular case may justify departing from such methodology. This can be for the benefits of the undertaking concerned, but this can also be against them. We have a recent case, which is the AC Treuhand case, in which you had one undertaking which participate in the cartel in a very particular way, in the sense that he was mostly a facilitator. He was basically hosting meetings, he was circulating information, but had no sales, had no activities in the market product. Obviously, it said, well, I shouldn't have a fine, where's my sales? And the Commission actually set up a fine using a different method, saying, well, your situation is exceptional, we do not apply the guidelines. This is quite normal, and it's not a problem in terms of legal certainty or equal treatment, because when the Commission does that, when it doesn't apply its guidelines, then it is under an higher duty in terms of explaining why it does so, and it really must demonstrate that there are good reasons for departing from its policy. The second reason why guidelines are no regulation is that they are not binding on the General Court. The General Court, in terms of competition law, has what we call an unlimited jurisdiction. That is to say that the court can modify fines for any reason it sees fit. So obviously, it is not bound by guidelines. But then you can have situations in which the General Court considered that there had been a violation of the guidelines, but the actual amount of the fine was sufficient. So it can work both ways. It can both work in favor of the undertakings. It can also work in favor of the Commission. Okay, those were my very brief and quick comments on guidelines in EU law. Now, based on that, I would like to express my comments on the draft proposals, focusing on the issues of legal certainty. And here, pardon me, I would distinguish between issues of substance and issues of form or drafting. In terms of issues of substance, I will say that I find that there are elements of legal certainty which are much higher in the draft proposal than in the 2006 guidelines. Notably, one changes from the 1998 guidelines to the 2006 guidelines was that the commissions decided not to use the repartition between most serious, serious, and minor offense. This is something which was criticized by academics, criticized in the business world, and I think it's a very good thing, but then I'm only expressing my personal opinion, that the draft proposal are not going this way, and that there's a clear distinction in paragraph 9 between 4 types of offenses relating to 4 clear stated types of infringement, for which basically undertakings can have a clear idea that if they're going into that direction, well, they will be facing with that type of sanction. That's my first comment on substance. My second comment on substance, and here I might be of a different opinion than DG Comp, if I understand well. I find it a very good thing in terms of legal certainty that aggravating circumstances in the draft proposal are expressed in an exhaustive way. It has never been the case because the Commission has always seen fit to consider that both in the 1998 regulation and the 2006 that the sky is the limit or 10% the limit, and if we find that you've been naughty in a different way than we first thought, we should punish you for that. Well, I think that in terms of legal certainty, a word such as such in our guidelines is not extremely good, and I don't think it will be a very good thing if you were to change it into a limitative list. But that's my personal opinion. So those are, I think, 2 good things in terms of substance. Now, listening to the very interesting speech of Madam Vice Chairman, I found out something which I am not too sure of, but as I said, I've only had the document a few days ago, so forgive me if I say something stupid, but it's this idea of benefit of or revenues as a means to establish the basic amount of fine. Well, we have the concept of sales in the 1998 and the 2006 regulation. So basically, the basic amount of fines will be based on the sales. Sales is a wide concept. If you have, for instance, an agreement on derivatives, obviously sales will be established in a specific way. So it's a wide concept that can be used to adapt to the situation. The good thing is that it is objective. Whether the company has been making a lot of profit out of its anti-competition behavior or basically been unproductive in it, it will be punished in the same way. And in terms of debtors, that's quite a good element. And also, how do you measure advantage? I mean, if we change subject and if we're looking at state aid litigation, I can tell you that the Commission and the General Court have been suffering for years and years to find out whether a given measure has provided an advantage to a certain company. It's such a wide concept, such a vague concept, that it's open to all types of agreements. So I don't, well, as I said, it's my personal opinion, but in terms of legal certainty as well as deterrence, I think something as vague, as complicated as advantage can be quite difficult to master in practice. Now, those were my 3 comments on substance. I will just make 1 short comment on drafting and form, but please bear in mind that I only had the English version. If you compare the 2006 regulation with the draft proposals, there's a clear difference. I mean, reading the 2006 guidelines, it is clear that the Commission will apply this policy. save in exceptional circumstances. But then it will be under an extra burden in terms of explaining why it did so. When I read Article 8, 9, 10, 11, the language seems to imply that it is merely a proposal. We might do it, we might not do it. The abundant use of the word "it is recommended" in a way could lead people to believe, well, I will never be able to enforce that in front of a court, because the Commission will say, well, I didn't bind myself, I just made a mere proposal. So I think the approach that we have in the 2006 guidelines, which is to say, as a principle, we will be bound by a word, save in exceptional circumstances, point 37, is probably, well, I don't think if it's better or not, but it gives a clear picture in terms of legal certainty. And also, when the Commission does not apply its guidelines, it is really, I mean, the onus of proof is on her, is on it. Well, I don't know if I've respected my time, but that will end my comments, and I thank you for your attention.